Okay. All right, we're now live on YouTube, and let me see if I can give you back the host spotlight.
Thank you, Judge.
We'll see how what that does, if anything, to the YouTube. Okay, you should be host now.
Yes, Judge, thank you.
All right, very good. And Mr. Burkett, if you'll unmute yourself, please.
Yes, Judge, how are you today?
Good, very good. All right, today is April 1 of 2021. I believe it's 1:03 p.m. This is a remote session of the Third Circuit Court for the County of Wayne Criminal Division. My name is Judge Lawrence Talon. We are broadcasting live on YouTube, and we also have a court reporter, and we're probably also recording on Zoom as well, is my guess. And this is the case of the people of the state of Michigan versus Eddie Ray Johnson. And it is case number 19-006751-01-FC. May I have the appearances, please, of the parties? First, starting with Mr. Abuzaid.
Good afternoon, Judge. Hadi Abuzaid on behalf of the people, P75596.
Mr. Burkett.
Yes, Sean, good afternoon again. Raymond Burkett on behalf of Mr. Johnson. And as usual, we do not object to this thing being on Zoom.
Very good. Now, I can't see you. I can see your pencil, but it's all right. Very good.
Judge, I should tell you, I've been having a ton of problems with my Zoom. I called your clerk yesterday.
I was told, so I don't know if you're able to aim it any better or not. I can see the ceiling or the wall, but I see you. Very good. Perfect. Very. And Mr. Johnson, I see you in jail division 2. Could you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
You may put your hand down. Tell me your full name, please.
Eddie Ray Johnson.
And Mr. Burkett is your lawyer?
Correct. Yes, sir.
And do you consent to appearing today remotely by way of Zoom?
Yes.
Okay, all right. Okay, so the last time we were here, I know that Mr. Burkett filed a motion for a bond reduction and for production of medical records in order to support that bond reduction. And I adjourned till today because I hadn't heard back from the jail. So I did hear back from Chief Judge Kenny because he sent an email to the medical personnel at the jail that said as follows. Do you have any objection if I read that in the response, Mr. Burkett?
I do not. I haven't seen it, of course, but
I know. I didn't forward it to anybody. Is it okay I read it, Mr. Johnson?
Mr. Johnson, say it's okay. Yeah.
Yes.
Okay. So Judge Kenny wrote to the medical personnel there, Mr. Johnson is in the Wayne County Jail charged with murder first degree. He received gunshot wounds during the event. Through his defense attorney, he is claiming he is not receiving a machine to assist with his breathing, nor has he received the test results of some examinations he has taken. Can you check on these things and please give me an update on his concerns? Judge Kenny forwarded me the response that he received. I received the response on March 29 at 4:36 p.m. Or actually, I received it, right around that time. Okay. And it said it was addressed to Judge Kenny, and he simply forwarded it on to me. And he said, and it's from someone who works for WellPath, who I believe is the medical provider for the jail. It says, I did have an opportunity to review Mr. Johnson's medical record. and noted that he has undergone several tests since his initial booking on June 8th, 2021. I think that's actually supposed to be June 8th, 2019. But that's approximately when I think he was booked into the jail. Anyway, that's what the email says. So it says June 8th, 2021. But it's my understanding he's been in the jail since I know he's arraigned back in 2019. Anyway, it goes on. Per the medical record, he has undergone multiple lab tests, CT scans, and a swallow evaluation. His medical record indicates that all results have been shared with Mr. Johnson, including the results of his HIV test and CT scan. In reviewing his outside medical records, including his most recent clinic visit, I do not see any diagnosis that would indicate a need for a BiPAP machine or in order to support this claim. Mr. Johnson was diagnosed during this admission with mild COPD. However, this would not require the use of a BiPAP machine. In the interim, I will discuss Mr. Johnson's stated concerns during our morning provider meeting and have him reassessed to ensure that he understands his medical treatment. I will send a follow-up tomorrow following the medical team's review. Please let me know if you have any further questions. Now, I sent another email to Judge Kenny, asked if he'd received a follow-up, and he simply replied this morning that he hadn't, and he'd let me know as soon as he did. So that's the information I have on that. Now, the other question that was raised had to do with, as I recall, at one time or another, Mr. Burkett had indicated that they wanted the first trial date possible. So I spoke with our presiding judge, Prentice Edwards, this morning about that. As I've stated before, we've only had 2 jury trials since the state of emergency began in March of 2020. One was in September, one was in October of 2020. We've been hoping to get started back up, but due to the increasing COVID infection rates in Wayne County, we have not been able to get back up to jury trials. Although we're doing we're doing in-person hearings for other matters, just not jury trials. It's hoped that we'll be able to get started in May. And I discussed with Judge Edwards, Mr. Johnson's concerns, how long he's been in the jail, and he said, although he can't promise anything because we don't know what the rate of infection is going to be, and our ability to open up for jury trials is dependent upon the rate of infections, the health concerns in the state, Wayne County, and getting permission from Scale. But he would give this case high priority to try to get it to trial as quickly as possible, up at the top of the list. That's not a promise, but that's what he expressed to me. And I asked if the bond was changed and Mr. Johnson posted bond, what impact would that have on where it was he was on the list to get to trial? And it'd still be given some priority, but of course, people who are in jail would probably, receive priority. So I can't promise, other than the fact that Judge Edwards said, particularly if Mr. Johnson were in custody, he'd do what he could to see that this case received high priority in getting a trial date. Part of that also depends on the lawyers and the witness availability as well. A lot of moving parts. So I wanted to bring that to the party's attention. I don't know if that has an impact on Mr. Burkett's or Mr. Johnson's request for a reduction in bond or not. But I wanted to report back to you as to things that we talked about before and what I had followed up on and what I had learned. Any comments, Mr. Abu-Zaid or Mr. Burkett? Start with Mr. Abu-Zaid, and then we'll go to Mr. Burkett.
Judge, thank you for the update. I think we both appreciate the thoroughness with the court's recitation of that. The people have nothing to add. We would rely on the arguments we made orally during our last Zoom session, as well as the brief that the people have filed regarding bond.
Mr. Burkett?
Thank you. Yeah. Well, first of all, let me say that obviously you've gone through some extra efforts, and we not only appreciate that, but we respect that. But I find what the county jail has told you in a note totally unacceptable. Now they're talking about something that happened back in May, a year and a half ago. I'm talking about blood test that was given 2 months ago, and they said they'll get back with you. And like I told you before, the reason we want him out, and I think I made it very clear, that if you told me I could go to trial Monday, I don't think he's in medical shape to go to trial Monday. That's one, and since he's not a serious threat, he has no criminal record. All the witnesses testify to that. You can put a monitor on him and make him stay home. And prior to him going to jail, he had medical insurance. We could get him examined by competent, and put in parentheses, competent doctors. Now who's going to respond saying, we'll have another meeting and we'll get back to you. In the meantime, if his condition is deteriorating, they haven't given you any information except what happened over a year ago. That is
No. I don't think that's accurate. It says that he's undergone several tests since his initial booking on June 8th of 2021. That's obviously the wrong year since we haven't arrived at 2021 for June.
Right.
I assume they're referring to, because I know that he was, this crime occurred on June 2nd, 2021. I reread the preliminary examination transcript. He was in the hospital on shortly after the incident. And I know that when one of the police officers testified, they came back for the second interview of your client, he was being restrained, which was on the morning of June 3rd, I believe. So I
Correct.
figure that he's been in custody, and he was arraigned on the charges within a week of that date. So he's been under custody of the Wayne County Sheriff since right around June 8th of 2021,
Right.
2019, excuse me. So so
They have told you.
Go ahead. Go ahead.
Right? I don't mean to be cutting you off.
No,
Go
I'm
ahead.
sorry. Go ahead. No, you go ahead.
Where I say their argument or this note that they sent to you is totally ineffective, because they said they ran tests. What tests did they run? What about the test he was given 3 to 4 weeks ago? What about the medical staff that told him he needed a machine? Now, some secretary gets together and says, I read the medical records. He doesn't need it. This is just not acceptable. And one of the things we asked you to do, I'm sorry, I'm having problems with my thing again, and the prosecutor said he has no objection, required them to give us his medical records and let our doctors take a look at it. I don't think that's being unreasonable under these conditions.
Okay. All right. Okay. All right, there's two ways I look at it. One is far from the I mean, I can hear his voice is hoarse, but based on the information that I've received, I think the report back is satisfactory as far as his medical condition. I'm not basing my decision as to what as to whether or not he should be released on bond based on his I don't believe that he's receiving inadequate medical attention based on the information I've received. So that's not my basis for my bond decision. But I am asking you is what Mr. Johnson's position is with regard to his motion for reduction of bond in relationship to what impact it may have on his ability to get a speedier trial. If he's able to comment on that.
Yes, may I?
Sure.
Oh, okay. Yes, Your Honor. First of all, if I want to make it, with all due respect, I respect your position from the note that they sent you from the county jail. But you nor I are doctors. And whoever wrote that note was not a doctor. That was some secretary that wrote that note.
I don't know that, but I don't know that one way or the other.
Okay. But however, as I told you before, if you told me that he can go to trial Monday, I don't think medically he can. And I think to say, well, we're going to let it, we'll give him a trial right away, even though you say he's medical, then he's being denied a due process, because I don't want to go to trial with a sick patient that can't communicate with me. And that's the problem that I'm having right now. And if there's no logical reason that he shouldn't be a bond reduction, and let me have him examined by, quote, real doctors who can make an intelligent decision, and we can hear from medical people. Okay. That's my whole position.
All right. So I take it, in other words, Mr. Johnson recognizes that if bond is changed from remand, that it may have an impact on when his case goes to trial, because priority might be given to other defendants, particularly those who are currently in custody.
We understand that, and we would agree to that.
Right. So you understand that. Is that correct, Mr. Johnson? Okay. I see you nodding your, okay, very good. I heard your answer, and I saw you nod your head yes, and I saw you raise your hand. Okay. All right. So here's my decision. And let me pull up my notes. I also re-reviewed the motion that you wrote regarding bond back in 2000, on or about September 16 of 2019. It was dated September 13, 2019, when you signed it for a motion for a bond reduction. And I think that's right around the time it first came to my court. And I think that's the only written motion there's been for a bond other than this last one. And I think this last one is the first time there's been a written bond, a motion for a bond reduction since the case has been in front of me. I note that
can I respond to that, Your Honor? Because I think you got the facts not correct.
Go ahead.
Your Honor, when you got the case, and when I wasn't, I don't, it might have been labeled bond reduction, but the judge had already ruled that he was entitled to bond, that he was going to leave it to you to set the amount of the bond.
Right.
So what?
Judge Hammer left it at a remand. So at the time that you made that motion in front of me, he was under remand status.
He was, but he also stated that he's definitely entitled to a bond on the charge of a second-degree murder.
Right. So you were asking me to reduce it from a remand. Is that correct?
Yeah, but he said it would be unfair for him to put an amount on the bond when you're going to be the one handling the case. But yes.
Okay.
Yes.
Right. I think our distinctions are without any significance right now in that regard. But since the pandemic began in March of 2020, I believe that this motion that I'm deciding now is the first motion that's been in front of me since then for a reduction of bond, based on my recollection and no previous written motions, at least since the pandemic began. I know that there had been a pretrial services report that was done, and it's dated October 11th of 2019. and I reviewed that as well. And I note that based on the information I have, Mr. Johnson just has one prior conviction, and that's from when he was 20 years of age. He was born, I believe, on August 19th of 1983. And that was in case 03-01061-01-FH. That was for an attempt unlawful driving away of an automobile when he was 20 years of age. He was placed on the Homes Youthful Trainee Act, I believe, on August 26, 2003. There was a violation of probation, and his HIDA was revoked by Judge Ewell on October 29th of 2007. And during that case, there was one capious history, which they referred to in that pretrial investigation summary. And that was he says he didn't show up for the preliminary examination, and they issued a bench warrant on September 8th of 2003, and they set aside the capious 2 days later on September 10 of 2003. That's his only prior criminal conviction that I am aware of. And that's the only capious history that I'm aware of. They do so I reviewed it regarding his personal history, that they had interviewed his mother, and that she said he could live with her if he was released on a bond. I read about his work history. I'm familiar with the allegations and the charges that he's charged with first-degree premeditated murder and felony firearm. They also use a risk assessment tool that I reviewed as well. Although I think that based on my review, they did make an error on it. They had him assessed at an average risk, but I think he's actually a low risk based on this. Based on he'd been at the same address for more than 4 years. He was employed. There was the one prior felony. He was over 30. He was not on probation or parole. And so I think that his risk assessment is actually low. I'm certainly not, and the other thing I take into account, and I do this for all defendants who are in custody at the present time, and that's based on a Michigan Supreme Court order in People versus Chandler, which was a Supreme Court order 161265. And that, as well as I can't open it up right now, but there we go. Administrative order number 2020-01, which says that for pretrial release, in addition to giving consideration to other obligations imposed by law, trial courts are urged to take into careful consideration public health factors arising out of the present state of emergency in making pretrial release decisions, including determining any conditions of release. And in the Chandler case, the Supreme Court order vacated a trial court's order that denied the defendant's emergency motion to modify bail and held that the trial court abused its discretion by failing to give adequate consideration to administrative order number 2020-1, which directs courts to consider the public health factors arising out of the present public health emergency to mitigate the spread of COVID-19. Because in that case, the record did not support the trial court's conclusory determination, went on further, that the defendant was likely to fail to appear for future proceedings. and that he posed a danger to the public if he is granted pretrial release. I recognize that although I've stated that I believe that Mr. Johnson's receiving adequate care in the Wayne County Jail, that his health is compromised by some COPD and the fact that he did receive a severe gunshot wound in 2019. And I also take in consideration also the fact that the Wayne County Jail has done an excellent job in terms of keeping COVID rates of infection very low. And some people might say that someone's safer in the jail than they would be out in the public. But I do take that into consideration. I also take into consideration that the defendant is about 37 and a half years of age now. And the court does not believe that he's a flight risk. The court also, despite the fact that he has been charged and bound over on first-degree premeditated murder and the charge of felony firearm, does not believe that he's a danger to the public in general. That's not a comment on the proofs in the case one way or the other. It's a recognition that the case involves the defendant and Miss Williams, who had been in an intimate relationship for a number of years. And the court does believe that that the defendant will appear for court if he does post bond. And that he's, as I said, not a flight risk and not a risk to the public in general in terms of public safety. So for those reasons, the court will grant the defendant a bond of $100,000 cash surety for 10%. With the GPS tether, with house arrest, with the exception of attending medical appointments and lawyer appointments with Mr. Burkett.
Okay.
Almost not done. He's to have no contact with any of the witnesses in the case. And I assume he would still be living at his mother's address?
That is correct.
All right, and he's to stay at his mother's address. And the other, I think that's probably, in the other conditions, I think he probably understands that he has to appear in any court hearing and abide by any judgment entered in this case and surrender to serve any sentence imposed, and obviously not to leave the state of Michigan without permission, not to commit any crime while released, and immediately notify the court of any changes in address or telephone number and abide by the conditions of the GPS tether. Okay.
Yeah. I have one question to ask of you, Judge.
Yep.
I understand by court hearings, everybody will be assuming that's a court hearing in this murder case, but case that he's charged with. But I want to make you aware that he's been served with papers from the family about property that they're trying to take from him by the deceased family, insurance papers and all that, that will require us to appear in Wayne County probate court.
I assume that's going to be all by Zoom.
I hope so.
Okay.
Yeah, but I just want to make you aware of that.
All right. I assume that's going to be all by Zoom.
Okay.
If it's not, let the court know. And but those are my court orders.
Gotcha.
Okay.
Judge, and just for the record, the people would object to that reduction in bond.
I understand. You know, I've only in my 30 some odd, 35 plus years, I've only had one other defendant on a case that I was involved in on first degree murder who was not on a remand. And that's when I was a prosecutor. And he did show up to court even after he took a plea to second degree murder with a very high sentence to turn himself in for sentencing. I judged this case individually. And as I indicated, it's not based on the merits of the case. He's still presumed to be innocent. And based on the risk factors that I don't believe he's a flight risk, and I don't believe he's a danger to the public.
And Judge, if I may place for the record as well, I indicated orally at our last motion as well as in the written motion that the people filed, this didn't just involve one person being in the home, being Detective Williams. Who was,
right. I recognize that. You mentioned that child. Right. I recognize that.
I'm sorry, Judge. I didn't mean to interrupt the court. This involved the child that was on the other side of a wall, in which one of the bullets that was fired in this case could have penetrated. And the only reason why we know that, where this little boy was is because when the responding officers responded to the scene, they found this little boy shaken up in his room, and they had to put a blanket over his head to transport him from the room over his dead mother in the hallway. So the people take issue with the position of the court indicating that he is not a danger to the public when it's not just Detective Williams. There was another little boy that was there, could have been struck, and there was the brutal way that Detective Williams was in fact shot based on this court's knowledge of the Michigan State Police reports. And
I don't minimize what occurred on that night in any way, shape, or form. I just believe that he at this time does not present a danger to the general public.
Would the court consider then, if the court's inclined to give a bond, would the court consider $100,000 cash, no surety, with the same provisions if counsel was able to meet that?
No, I've made my ruling. Okay.
Thank you, Judge.
All right. So we need another date.
Sure.
Okay. There's nothing pending other than to wait and see if we get a trial, right?
Correct.
How about if I give us a date? I'm going to give I should do an internal review date. How about if I do an internal review date, Amber, of August 2. So this is an internal review date for the court to determine, to see if the case has already been scheduled for trial. It won't be a court hearing date. And I'll set any dates after that as necessary. If the parties need to see the court for any reason, either in chambers or with another hearing, contact my staff. And we'll set up another date, okay?
Okay. Judge, one final question. Are you going to require the county jail to give us its medical records?
No.
Okay.
And Judge, I apologize. I have one question as well. I don't know if the court's able to answer it. Given the date that the court set out in August, does the court have any information as to the plan moving forward with cases that are going to be tried in the sense that I know that before there was 2 judges that were brought in to
I told you everything I know. I know nothing more than that. Although I expect that I'll be trying the case, presiding over the case.
Okay.
That's my anticipation. Okay. All right.
I have nothing further, Judge. Thank you.
All right. Thank you very much,
No.
Mr. All right, Mr. Johnson, you can go with the deputies.
Thank you, Judge. Okay.
Thank you, Judge. Have a good day.
You too.
Judge, this is Mr. Antoine Johnson at Jail Division 2 now.
All right, thank you very much. All right, today is April 1, 2021. This is a remote session of the Third Circuit Court for the County of Wayne Criminal Division. My name is Judge Lawrence Talon. This is the case of the people of the state of Michigan versus Antoine Johnson, case number 19-000795-01-FH. Appearances, please. APA Hamilton, please.
Afternoon, Your Honor. AJ Hamilton, standing in for Brian Fox, P number 82591.
Mr. Perkins.
Yeah, good afternoon, Your Honor, and good afternoon to your staff. May it please this honorable court. My name is Todd Russell Perkins, P 55623, appearing on behalf of Mr. Johnson on this adjourned date, at which time we do have all the reports that were needed. Apparently had been sent before, but we didn't get them, and your staff was helpful in getting that to us.
Okay. And Mr. Johnson, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down. Tell me your full name, please.
Antoine James Johnson.
Mr. Perkins is your attorney.
Yes.
You consent to appearing today remotely by way of Zoom.
Yes.
Okay, thank you. Okay, so, but his case, last time I looked, the case was still in 36th District Court, his new case, right?
Right.
You are trying to wait till that case gets to
you,
Third
yes.
Circuit.
Yes.
Okay. So what should I do today? Just set another date?
Yeah, set another date, and I just wanted to let the court know, as it relates to that 36th District Court case, so the confusion was that both courts ordered a forensic evaluation. So we have the benefit of two separate reports. We have a benefit of two competency reports and two forensic evaluations for criminal responsibility reports. And so I have had an opportunity. I met with his mom and dad and uncle on maybe 2-3 days ago. And I would also state for the record, his mom is unable to appear by way of watching Zoom or watching YouTube. She's not feeling well today, but she's coming by my office on Monday. That we are seeking to retain Dr. Shiner for our independent. And I would ask the court, I would ask Your Honor to be able to prepare an order, send it to Ms. Hamilton and copy Mr. Fox on an order to have an independent evaluation of him. I have all the medical records and all the forensic information for Dr. Shiner.
Okay. Dr. Shiner's being retained, I
Yes.
take it. Is that correct?
Yes.
Okay.
Yes, he is.
All right. Okay. So you can send the proposed order to APA Hamilton and or Fox, and
Okay.
Assuming that stipulates to it, they'll send it to me for entry.
Okay. And so if we could put that off, your date off, because I'm going to do the same thing for Judge Jones. It just will be more efficient this time because it'll just be one interview and two different reports that Dr. Shiner is going to generate. But if you could put that off, at the earliest we would be back, if we were in Judge Jones, at the earliest we would be back is 3 or 4 weeks. We would need at least 30 days, Your Honor.
Okay.
You need a date, Judge, in 30 days?
Let's go out further than that. I'm looking, the farthest date we can go in May. It'd be May 28, docket D at 1 o'clock.
Correct.
Should we put it on that date? And if they need us beforehand, we'll move it up.
Okay, that's the wonder, Your Honor.
Okay. May 28th, docket D, 1 p.m. It's a Friday. Okay,
All right. Well, hey,
All
I
right.
look forward to seeing you in person one of these days. So in court.
Yes, maybe
Yeah.
before then. All
Yeah,
right.
please.
Okay, thank you.
Yep. All
All
right.
right,
See you, everyone.
Bond stays at a remand.
All
Your
right,
Honor, I'm sorry, can you repeat that one more time, the date on that?
Friday, May 28th, 1 p.m.
Okay, thank you.
You're welcome.
Thank you.
Judge, this is Mr. Alante Williams at Jail Division 2.
All right. Do we have Mr. Okay. Ms. James is connecting. All right. Today is May 1, 2021. It is 1:43 p.m. This is a remote session of the Third Circuit Court for the County of Wayne Criminal Division. My name is Judge Lawrence Talon. These are the cases of the people of the state of Michigan versus Larry Bailey and Alante Williams. Mr. Bailey is defendant number 1 on both of these cases. Mr. Williams is number 2. They are cases 20-000697-FC and 20-000699-FC. Appearances first. Let's start first with the people of the state of Michigan, please.
Good afternoon, Your Honor. AJ Hamilton on behalf of the people appearing on behalf of Brian Fox, P number 82591.
Okay, and let's go to Ms. James, since she represents Mr. Bailey, who's defendant number 1.
Good afternoon, Your Honor. Nicole James appearing on behalf of Mr. Bailey. Your Honor, Mr. Bailey is not present, and I would ask to waive his presence for the purpose of this hearing.
Okay.
He broke his phone right before the hearing. He's at the store trying to get a new phone.
Okay. All right. I'll waive his presence. And Mr. Johnson. You have to unmute.
Good afternoon. Bertram Johnson appearing on behalf of Alante Williams, Judge.
All right. And good afternoon, Mr. Williams. If you'll raise your right hand. Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down. Tell me your full name, please.
Alante Van Williams.
And Mr. Johnson is your attorney?
Yes.
You consent to appearing today remotely by way of Zoom?
Yes.
Okay. All right. Thank you very much. When we were here last time, I was asked for and granted an adjournment till today. I believe that the parties wish to discuss the case further with the supervising docket attorney, APA Bradley Cobb. And I think we were here on March 11th. And so we are now back April 1. So what do the parties have to report?
Yes, Judge. In addition to that, one of my reasons for asking for that adjournment was to review the transcripts with my client. I was able to go down to the county jail and safely meet with him, and we were able to go over the case extensively. It was a very fruitful visit. I also spoke with Bradley Cobb. We had a fruitful conversation. Right now, Judge, I put in a call. He said he was going to, as soon as he got the file, he would look at it and he would sincerely consider my request. We're presently, I called today. He's not, I haven't got a return call, but I'm sure Mr. Bradley is gonna get back with me. So I'm just asking to put it over for a week, Judge. And we possibly may be able to reach a favorable resolution.
James?
I've also, Judge, been in communication with Miss James, consistently keeping her apprised of my contacts with Mr. Bradley, so that these cases, if they resolve without going to trial, that both parties may join in this resolution.
That's correct, Your Honor. Your Honor, we've been in communication. We're just waiting on Mr. Cobb to give us an answer.
My next available date is Monday, April 12th at 1 o'clock. Does that work?
That's
Yeah,
good.
that works for me, Judge.
That's a good date.
Okay, Monday, April 12th, 1 o'clock. That'll be docket C, like in Charlie.
Thank you.
Okay, all right, we'll see you then.
Thank you.
Bond remains at remand. Thank you.
Thank you. Have a good one, everyone.
You too.
Thank you.
Judge, this is Mr. Ronald Gray at Jail Division 2 now.
Okay. Okay. Today is April 1 of 2021. It is 1:48 p.m. This is a remote session of the Third Circuit Court for the County of Wayne Criminal Division. My name is Judge Lawrence Talon, and this is the case of the people of the state of Michigan versus Ronald Gray. It's case number 20-002195-01-FC. Appearances, please. Ms. Shackelford?
Good afternoon, Your Honor. Victoria Shackelford appearing on behalf of the people, 68574.
And Judge, good morning or good afternoon to you, also to the staff. Michael Woodyard is my name. My P number is 64612. I'm appearing on behalf of Mr. Ronald Gray, who joins us on the Zoom screen.
Okay, and good afternoon, Mr. Gray.
Good afternoon.
Would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down. Tell me your full name, please.
Ronald Gray.
And Mr. Woodyard is your attorney?
Yes, sir.
And do you consent to appearing today remotely by way of Zoom?
Yes, sir.
Okay, all right. I was just looking at this a little while ago to remember the last day we were here. I think it was earlier in March, beginning of March 4th, I think it might have been, right around then. And I was asked to adjourn, I guess I was asked actually in advance of the hearing, to adjourn it to today's date. So what can I do for the parties today?
Your Honor, the Zoom proceeding raises challenges for all of us. I will indicate, Judge, I emailed him about 40 minutes ago to see whether or not I could have a brief breakout room with Mr. Gray, but it appears as though that's not possible until we're on the record. And so I apologize, but could I have 2 minutes?
Yes.
Thank you.
Amber, can you do that for me?
Yes, Judge, doing it now.
Yes, please.
Oh.
Thank you.
Judge, parties are back on gray.
I'm sorry, they're back. Thank you very much. Just trying to do two things at once. All right. Okay, welcome back, Mr. Woodyard and Mr. Gray. You had an opportunity to meet in the breakout room, Mr. Woodyard?
We did, and Your Honor, it was a very brief meeting. I wanted to just confer with Mr. Gray on one outstanding issue. Your Honor, we were last before the court. I had asked for a period of time to assess whether or not a motion to suppress the statement that Mr. Gray had provided to the police, whether a motion to suppress that statement would be availing. I indicated to Mr. Gray, and I had previously indicated to the court and counsel, that in my assessment, such a motion would not be appropriate given the circumstances, and that I didn't think it would, that I wouldn't be filing it. I've conferred with Mr. Gray, and I think that we're ready to proceed, Judge, with today's pretrial.
Okay, go ahead. I'm listening.
Your Honor, the prosecution has tendered an offer of pretrial resolution in this case. I've gone over it with Mr. Gray, although I certainly would hope the prosecution may put it on the record one more time. I think they've done it a couple times, but just one more so that it's clear. And I don't believe that Mr. Gray is in a position to accept that offer.
Okay, and let me ask, hold on one sec. Is that offer in writing by any chance? Has it been reduced to writing? You're muted.
Yeah, sorry. Judge, I may have emailed it to defense counsel at some point over the course. We've had numerous discussions, so I'm certain it was put in either a text message or an email at some point, but it's been the same offer that's been available to defendants since prior to Mr. Woodyard getting on the case.
Okay. All right. And there's been one information that's been filed and no amendeds. Is that correct?
Correct.
All right. Well, how about if I listen to it? Because I have to write it down since I didn't get a copy, I don't think. But anyway,
Okay.
Go ahead.
Judge, the offer is defendant would plead to a reduced count of homicide second degree and a count of felony firearm associated with that homicide, which would be with the sentencing agreement at 18 to 40 years on the homicide plus 5 on the felony firearm because it is enhanced.
Okay.
And all I'm sorry, Judge, and all remaining counts would be dismissed as part of that plea.
That'd be count 2, the assault with intent to murder, count 4, the felon in possession. And what about the, then there's a count.
Can I, Your Honor?
Yeah, go ahead.
Okay, so count 2, which is an assault with intent to murder, count 3, which is assault with intent to murder, count 4, which is possession by a felon, count 6, which is felony firearm, count 7, and count 8, both are also felony firearms, all would be dismissed as part of the plea.
And the habitual?
Your Honor, if defendant was going to take the offer, I would withdraw the habitual offender notice.
So be counts 1 and 5, 18 to 40 plus 5.
Correct.
Okay. May I voir dire Mr. Gray on this offer, Mr. Woodyard? You're muted.
Yes, Judge, I apologize. Yes.
Thank you. All right. So, Mr. Gray, I'm going to go over the charges that you're facing and the offer by the prosecutor and ask for your decision, okay?
Yes, sir.
In count 1, you're charged with homicide, first-degree murder, and that carries a mandatory penalty of life without parole in prison. In count 2, you're charged with assault with intent to murder, and that carries a maximum penalty of life for any number of years in prison. In count 3, you're charged with assault with intent to murder in another count, and that also carries a maximum penalty of life or any number of years in prison. In count 4, you're charged with being a felon in possession of a firearm, and that carries a maximum penalty of 5 years in prison. In count 5, you're charged with felony firearm weapons second offense notice, and that carries a mandatory 5 years in prison, which would have to be served consecutively with and preceding any term of imprisonment imposed for count 1, murder. In count 6, you're charged with weapons felony firearm second offense notice, and that carries a mandatory penalty of 5 years in prison, which would have to be served consecutively with and preceding any term of imprisonment imposed for count 2, assault with intent to murder. In count 7, you're charged with weapons felony firearm second offense notice, and that carries a mandatory penalty of 5 years in prison, which would have to be served consecutively with and preceding any term of imprisonment imposed for count 3, assault with intent to murder. In count 8, you're charged with weapons felony firearm second offense notice, and that carries a mandatory penalty of 5 years in prison, which would have to be served consecutively with and preceding any term of imprisonment imposed for count 4, weapons firearms possession by a felon. The prosecutor also filed a habitual offender fourth offense notice pursuant to the Penal Code, and that increases the your minimum sentencing guideline ranges on counts 2, 3, 4, and 2, 3, and 4. And it increases the maximum penalty you face in count 4 from 5 years in prison to life in prison. Do you understand that?
Yes, sir.
Okay, did I state that correctly, Ms. Shackelford and Mr. Woodyard?
Yes, Your Honor.
You did, Judge.
Okay, and the prosecutor has said, if you plead guilty to the reduced count of reduced charge of murder in the second degree, which carries a maximum penalty of life for any number of years in prison for count 1, and felony firearm second offense notice for count 5, with a sentence agreement that I sent you to serve 5 years in prison, the mandatory 5 years in prison for count 5, felony firearm second offense notice, and a minimum of 18 years to a maximum of 40 years in prison for the reduced charge of second degree murder in count 1, that they would dismiss counts 2, count 3, count 4, count 6, count 7, count 8, and withdraw the habitual offender fourth offense notice. Did I state that correctly, Ms. Shackelford, Mr. Woodyard?
Yes, Your Honor.
Yes, Your Honor.
Okay, so just so you understand that, that would be second degree murder and felony firearm second offense notice with a sentence of 5 years in prison for count 5, felony firearm second offense notice, a mandatory 5 to be served consecutively with and preceding a term of 18 to 40 years in prison for murder in the second degree. Okay, do you understand that, Mr. Gray?
Yes, sir.
Have you had a full, fair, and complete opportunity to discuss this offer with Mr. Woodyard?
Yes, sir.
Have you had time to think about your discussions with Mr. Woodyard?
Yes, sir.
All right. And have you made a decision about what it is you want to do?
Yes, sir.
And what is your decision?
To go to trial.
Okay. You wish to exercise your constitutional right to a trial by jury
Yes, sir.
and to reject the prosecutor's offer. Is that correct?
Yes, sir.
Has anyone promised you anything in order to get you to make that decision?
No, sir.
Has anyone threatened you?
No, sir.
Is that your own choice?
Yes, sir.
Are you making it freely and voluntarily?
Yes, sir.
Okay. All right. Anything else I need to ask?
No, Judge.
Okay. And Mr. Woodyard, I don't know if you filed I can't remember, did you file anything saying you're withdrawing the motion to suppress? I can't remember. Did you actually file the motion to suppress? I think you did.
I had not actually filed a paper motion, Judge, no.
Okay. All right. And Mr. Gray, you're in agreement with Mr. Woodyard's decision not to file that motion to suppress your statement. Is that correct?
I kind of really didn't understand what he mean by not wanting to suppress it.
He said that he did feel there was a basis for filing the motion, if I understand correctly. Is that correct, Mr. Woodyard?
Yes, Judge, after carefully reviewing the actual recorded statement, identifying what the issues were that Mr. Gray had brought to my attention and assessing those issues in light of controlling what I understand to be controlling law, it was my decision that there would not be a legal basis to contest the potential admission of that statement against Mr. Gray. And so therefore, in my judgment, I determined that it was not appropriate to file a motion.
Okay. I guess it's not something I really need to ask his concurrence on.
Yes.
Okay. All right. Okay. All right. So I guess the only thing left is to go over the jury trial readiness form. The people filed a witness list before. That was filed by Ms. Shackelford last year in August of 2020. And she's filed the jury instructions as well, I believe. Is that correct?
That is correct, Your Honor. I also filed an amended witness list at some point over the past year as well.
Okay, maybe you can email that to us
Okay.
again and to Mr. Woodyard just to make sure that we have it. Any witnesses anticipated on behalf of the defense?
Your Honor, there might be a couple, and candidly, Your Honor, I haven't prepared a witness list. I don't know whether Mr. Evans, prior to me, in consultation with Mr. Gray, had filed one, but Mr. Gray and I have not updated it if that is the case.
I do see one actually. Actually, that's no, that's the people's witness list.
I don't recall procedurally. I had been under the impression that this case was on the trial ready docket.
Yeah, it's got to go back on. It'd been taken off. Although it's probably gonna be based, it'll be the jury trial readiness form will be re-updated, and it'll probably be based on the number of days in custody. All right, so it looks like we're all set as far as motions, correct?
Yes.
Correct.
And are we all done with the labs now?
Everything is done, Your Honor. Everything's been handed over. The only issue is I just realized as we were sitting here, my officer in charge on this case has since retired. So I may have to, I'll obviously reach out to her and find out who has taken over the case, but I might have to file some sort of amendment just on my witness list just to add a officer in charge, whoever's assigned.
Okay. All right. When do you think you'll be able to tell us, Mr. Woodyard, about any witness lists that you may be filing? Because I know that when I filled out the jury trial readiness form with Mr. Evans, there were no witnesses listed on behalf of the defense.
Judge, it seems like every time anybody appears in a court hearing, we end up moving again to appear at a later date. I wonder, maybe we could come back in a week. Miss Shackelford could get the new OIC's information, and I could confer with Mr. Gray, and we could prepare for 1 week from today to fill out the jury trial readiness form, or
Okay.
whenever you're ready.
It'll actually be April 12th at 1 o'clock. Would that work?
That will work for me, Judge.
Judge, the 12th is
On Monday.
I have an in-person hearing in Garden City at 10:30. I don't know that I'll be done, and I don't want to set this court up to be waiting for me. Is it 1 o'clock, you said?
Yes, 1 o'clock.
I'll be done. Let's say, yes, that's
Okay.
fine, Judge.
All right. I'll see you April 12th, 1 p.m. Docket C, like in Charlie.
Thank you, Judge.
And Mr. Gray, I'm going to come down and visit with you in person. Okay, sir?
Okay, we'll see you then, Mr. Gray.
Thank you, Judge.
All right.
Judge, this is
All right.
Mr. Rennell Stowers.
Okay, I'm going to be a few minutes because I have to step away. Okay.
Okay.
All right. Amber and Lynn, I have to step away to attend this other matter. Okay. I'll be back as quickly as possible.
Okay, yes, very good.
Thank you.
Hello, Jim.
Mr. O, you need a breakout room with Division 1, correct?
I do need one person. I'd like to
Yes,
talk
please.
to Mr. Anthony Drain. I've already talked to Mr. Hill.
Okay, I'm just going to put you in the breakout room and you can let them know who you need.
Thank you.
Okay, I'm going to put you both in each one.
Amber, are you able to put me in a breakout room with my client, Mr. Stowers?
Yes.
Okay. Let me see.
Did the court go on a break or they in the breakout room or something?
Yeah, Miss Cotton, the court is on a break right now, yeah. What just
Thank
happened?
you.
Yep. I don't know what just happened. Oh, there he is.
Mr. O, were you all set with the
Yes,
breakout room?
and Mr. Gordon.
So you met with everyone?
Yes.
Okay.
Does Mr. O'Donnell need,
No, I'm here.
okay.
I believe
You need,
so.
do you need to meet with anyone, Mr. O'Donnell?
No, thank you.
Okay, very good, thank you. The court will resume shortly. The judge is attending to another matter and will return shortly. Thank you, everyone.
Madam Clerk, I just had a quick question. This officer Cotton, Division 3. Were we going to see Mr. Halliburton, or is he good to go back to his pod? Are we just waiting on paperwork for him?
What was the last name? I'm sorry.
Halliburton.
Amber? They have Mr. Halliburton listed as a violator. However, he was already heard by Judge Thomas and has a review date set for May 25th.
Do you have the paperwork, Deputy?
I'm sorry, what did you say?
Do you have the paperwork for Mr. Halliburton?
No, we don't have any paperwork for him. I think that's what
Okay.
we were waiting. He was seen out of custody at a different, I think in Romulus, so we didn't have any paperwork, from Third Circuit regarding his case.
Okay.
And one more thing, if you got time, Mr. Sims was seen and his bond was reinstated like yesterday or the day before. I don't know if he needs to go in front of the judge either.
I don't believe so, but let me just make sure. What email should I send the paperwork for Halliburton to?
L. Cotton at Wayne County.
I'm sorry?
L. Cotton.
At Wayne County?
Yes, sorry.
Okay. And you have the paperwork for Sims, right?
Yes.
Okay. I'm sending it over now.
Thank you.
Push that. That's unmuted.
Okay.
Okay, Jail Division 3, we will need to see Willie Sims.
Okay, thank you.
Thank you. Hi, Judge. Good afternoon.
Hi, I'm in the right place, eh?
You are, Judge.
Okay, and just to make sure, I assume you are still the host, eh? Just double
That's
check.
correct, Judge. No, actually, you're the host
All right,
now. It shows.
all right. I'm just making you host again.
Thank
Okay,
you.
all right. I'm ready. What would you like me to do next?
Judge, I guess we can resume with Stowers. And
Okay.
Mr. Taylor, are you standing in for Ms. McCoy, I presume?
I am. Thank you.
Okay. All right. Okay. So let me turn the page. And is this Ms. Hamilton's case, AP Hamilton? Okay, good. Thank you.
Yes, I'm here, Judge.
Thank you. All right. Today is April 1, 2015. I read something on my screen. April 1 of 2021 at 2:54 p.m. And this is the case of the people of the state of Michigan versus Raynell Antonio Stowers. They are cases 21-000, 578-01-FH, and 15-008245-01-FH. May I have the appearances of the parties, please? First, starting with the people of the state of Michigan, please.
Good afternoon, Judge. I'm AJ Hamilton on behalf of the people, standing in for Brian Fox, P number 82591.
Okay.
Good afternoon, Your Honor. Edward Taylor, P57166, appearing on behalf of Mr. Stowers for the attorney of record, Robin McCoy.
Okay. And Agent Graham, are you appearing on the probation violation?
Graham appearing on behalf of the Michigan Department of Corrections.
All right, thank you very much. And good afternoon, Mr. Stowers. I see you're in jail division number 2. Could you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down. Tell me your full name, please.
Raynell Antonio Stowers.
And how old are you?
6.
I'm sorry?
26.
And how far have you gone in school?
11th grade.
Ms. McCoy is your attorney.
Yes, sir.
Have you had a full and complete opportunity to talk with her about your cases before coming in front of me this afternoon?
Yes, sir.
And do you consent to Mr. Taylor standing in for Ms. McCoy this afternoon?
Yes, sir.
And do you consent to appearing today remotely by way of Zoom?
Yes, sir.
All right. So I know there's been, because I've been told that there's been a plea agreement reached on the 2021 case, and Ms. McCoy asked me to give a preliminary evaluation of sentence on the probation violation, and I've done that, and I emailed that to Ms. McCoy and the prosecutor, I believe. I think I sent it to Mr. Curley. Did you get it, Ms. Hamilton?
I did not, Your Honor.
All right.
If I may, Your Honor, it's my understanding that that POV is going to be dismissed.
Yes, Your Honor. I talked to Brian Fox about this case earlier, and I also talked to Agent Graham, and our understanding is if Mr. Stowers is going to take advantage or avail himself to the plea agreement on the new case, then the people would have no problem with moving to dismiss the case that he has the VOP on.
Agent Graham?
Your Honor, that is correct. There's no objection to closing the probation without improvement as a part of a plea
With improvement?
Without improvement. And Your Honor, that was with understanding that the plea agreement was to entail an MDOC sanction for the defendant's new case.
Yes,
you seem, I remember that I was asked for a preliminary evaluation of sentence, and I gave one of 1 to 10 years in prison for the great bodily harm for the probation violation. I thought I did that on the record last time. Okay. So let's go ahead and put the offer on the record.
Okay, Your Honor, the people's settlement offers no charge reduction, but we are asking, or Mr. Stowers will plead to count 2, which is CCW, PAC code 750.227, which carries a statutory maximum of 5 years. The people are agreeing to dismiss count 2, firearms possession by a felon, and count 3, felony firearms. Also withdrawing the habitual 4th notice, with the sentence agreement being 1 to 5 at MDOC.
Okay. Was that the plea agreement, Mr. Taylor?
Yes, sir.
Forgive me.
How you doing, Your Honor?
I'm doing just fine. All right. And Mr. Stowers, did you hear and understand the plea agreement that's been placed on the record by the lawyers?
Yes, sir.
Is this what you've agreed to do?
Yes, sir.
You asked that I accept this plea agreement.
Yes, sir.
Are you on probation or parole other than being on probation for the assault great bodily harm case in the 2015 case?
No, sir. To be honest, my last probation day was January 15th, but I had caught the new. Yeah.
All right. So you understand that you are on probation for assault great bodily harm. You understand that?
Yes, sir.
Okay. And you understand that Ms. Agent Graham says that the probation department's going to move to dismiss the probation violation when I sentence you on the concealed weapon case with the sentence agreement of 1 to 5 years in prison. Do you understand that?
Yes, sir.
Okay. Are you on, because otherwise I always tell people, if you commit a crime while you're on probation or parole and then plead guilty, that it may have an impact on your probation status and may impact your sentence on your probation case. You understand that, right?
Yes, sir.
Okay. Well, I'm going to go over the charges with you on the information and the plea agreement as well. In the information, you're charged in count 1 with carrying a concealed weapon, to wit a pistol, that carries a maximum penalty of 5 years in prison. In count 2, you're charged with being a felon in possession of a firearm, and that carries a maximum penalty of 5 years in prison. In count 3, you're charged with weapons, felony firearm, that carries a mandatory 2 years in prison, which would have to be served consecutively with and preceding any term of imprisonment imposed for count 2, being a felon in possession of a firearm. You're also charged with being a 4th felony offender pursuant to the Penal Code. That increases the maximum penalties you face in counts 1 and counts 2 from 5 years in prison for each of those counts to life in prison. And it also increases your minimum sentencing guideline ranges for both of those counts. Do you understand that?
Yes, sir.
Prosecutor has said it'll dismiss count 2, the felon in possession of a firearm, dismiss count 3, the felony firearm, and withdraw the habitual offender 4th offense notice in exchange for your plea of guilty to weapons carrying concealed Actually, I think the counts are misnumbered as I look at the plea form as dated here.
No,
Which one? I guess maybe I'm just misreading it. Count one's the felon in possession, right?
Correct.
Okay, all right. I might have misstated the numbers, but
and I think on the plea form, it does look like a 2, but it's a 1.
yeah, okay. It's a fancy one.
Yeah, it's
That's
a
right.
fancy one.
Okay, all right. So once again, Mr. Stowers, just to make sure I'm clear, or so that I'm clear to you, if the offers, if you plead guilty to count 2, weapons carried concealed, which carries a maximum penalty of 5 years in prison, with a sentence agreement that I sentence you to serve a minimum of 1 year to a maximum of 5 years in prison, they will dismiss count 1, the felon in possession of a firearm, dismiss count 3, the felony firearm, and withdraw the habitual offender fourth offense notice. You understand that?
Yes, sir.
You have any questions about any of this?
No, sir.
And with all this in mind, how do you plead to count 2, weapons carried concealed?
Guilty.
If your plea is accepted, you will not have a trial of any kind. And so you're giving up the rights you would have had at a trial, including the right to be tried by a jury, to be presumed innocent until proved guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at the trial, to question the witnesses against you, to have the court order any witnesses you have for your defense to appear at the trial, to remain silent during the trial, to not have that silence used against you, and to testify at the trial if you want to testify. Do you understand each of these rights?
Yes, sir.
You understand that if I accept your plea, you will be giving up every one of these rights.
Yes, sir.
If I accept your plea, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Do you understand that?
Yes, sir.
Further, if I accept your plea, any appeal will be by leave of the Court of Appeals. That means there's no automatic right to appeal. Instead, you would have to ask the Court of Appeals to hear your case, and the Court of Appeals would decide whether to hear your case. Do you understand that?
Yes, sir.
Okay. I don't know, did Ms. McCoy have an opportunity to go over the settlement offer with you, a plea form?
Yes, Your Honor, she went over it with him.
She probably couldn't give you a copy or show you a copy, or is that right or wrong, Mr. Stowers?
She went over it with me, but I didn't get a copy.
Okay, all right. Okay, so do you understand that the rights I've explained to you this afternoon are the rights you would have had at trial that you're giving up by pleading guilty?
Yes, sir.
You understand you're giving up every one of the rights described in this form if I accept your plea?
Yes, sir.
There are some claims you'll be giving up if I accept your plea. You will give up any claim that your plea was the result of promises or threats that I'm not told about today, and also give up any claim that it was not your own choice to plead guilty. Do you understand that?
Yes, sir.
You understand that I don't have to follow the sentence agreement that you've entered into with the prosecutor, but if I decide not to follow it, I will let you withdraw from your plea of guilty. Do you understand that?
Yes, sir.
Other than what we've said in court today, has anyone promised you anything if you plead guilty?
No, sir.
Has anyone threatened you to get you to plead guilty?
No, sir.
Is it your own choice to plead guilty to this offense?
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Are you satisfied with Ms. McCoy's representation of you as your lawyer?
Yes, sir.
And are you satisfied with Mr. Taylor's representation of you here today?
Yes, sir, I am.
Okay. APA Hamilton, I don't have a copy of the information in front of me, so if you could provide us with the date and location, please.
Do you want me to ask the questions to Mr. Stowers, or you just want me to give it to you?
Mr. Taylor, if that's okay with you.
That's fine.
Go ahead, APA Hamilton.
Okay. Mr. Stowers, taking you back to November 6, 2020, were you in the area of Carpenter and Arlington and Hamtramck?
Yes, ma'am.
Okay, and on that date, were you in possession of a handgun?
Yes, ma'am.
Okay, and where was that handgun located?
It was in the car on the door.
And you knew that handgun was in that location?
Yes, ma'am.
Okay, and do you have a license to carry that gun?
No, ma'am.
If I could just follow up with a couple questions. Was that Hamtramck? It sounds like a silly question, I know, but is Hamtramck in the county of Wayne?
Yes, I'm sorry.
That's okay. Is that the county
Yes,
of
sir.
Wayne? Okay. And did you, were you in the car at the time the gun was in the car?
Yes, sir.
And did you carry or take part in carrying the gun in the car?
Yes, sir.
And it was a pistol, a real gun?
Yes, sir.
Okay, thank you. Are the parties satisfied that Mr. Stowers' statement of facts have satisfied all the elements of the crime to which he's pled guilty? APA Hamilton?
Satisfied, Your Honor.
Mr. Taylor?
Satisfied, Your Honor.
Are either side aware of any promises, threats, or inducements related to Mr. Stowers' plea other than those already disclosed on the record? Ms. Hamilton?
Satisfied, Your Honor.
Mr. Taylor?
No, Your Honor.
Is the court fully complied with the court rules? Ms. Hamilton?
Yes, Your Honor.
Mr. Taylor?
Yes, sir.
Once again, Mr. Stowers, how do you plead to weapons carrying concealed to wit a pistol in a motor vehicle?
Guilty.
The court believes that Mr. Stowers' plea is understanding, voluntary, and accurate. The court is also satisfied there's a factual basis to support a finding that you are guilty of this offense. Therefore, the court will accept your plea of guilty and will set a sentencing date. So, Mr. Stowers, one of the things I'm going to ask you when you come back for sentencing is because you have a right to be present in the courtroom for your felony sentencing. But as you probably know, we're meeting by Zoom because the courts are not open, just not generally, I guess. And I see Ms. McCoy's back.
Yes, thank you, Your Honor.
Did you talk with Mr. Stowers about whether he'll waive his right to be present in the courtroom for the felony sentencing?
I did not talk to him about that. I don't think that would be an issue in light of the pandemic. I mean, we can ask him now. I do know he wanted me to request from the court. He wanted to see if the court would release him for a couple of months to get his affairs in order. His girlfriend is pregnant and is due in July. So
I'm sorry, Mr. Stowers, I won't do that.
okay.
So, so the question I'm going to ask you is if you will waive your right to be present in the courtroom and consent to being sentenced by Zoom the same way we're doing it today.
Will Ms. McCoy be able to sign for my copy? I mean, will she be able to sign for me?
Well, we're going to send you copies of any documents that you need, your appellate papers and things of that nature. I'll tell you what, Ms. McCoy, you're probably going to talk with him before the sentencing anyway. You're muted. You're muted.
I was talking earlier.
Okay.
So no, Mr. Stowers, yeah, any documents, if there's documents that the court would email me, I would sign off. You know, I would so I would be available to do that, or I mean, they email it, I sign it, I send it back to the court. So yes, that would, if yeah, I guess that's a question. How does the court do that?
When you come back, you'll have had an opportunity to talk about that with Ms. McCoy, and I'll ask you what your decision is then, okay? All right. I see you nodding your head, yes. Okay. Because you have a choice. I can sentence you just like we're doing now by Zoom, and that'll happen sooner, or it'll take longer if you want to wait and do it. Want us to do it in the courtroom. It'll just take longer for that. Pardon?
We can do it like this through Zoom. This is fine.
All right. Amber, may we have a sentencing date for Mr. Stowers?
April 20th, docket B as in boy, 9 a.m.
Okay. I'll see you then, Mr. Stowers.
Reno.
Thank you.
Okay. Thank you, Your Honor. Hope that you all stay safe.
You too. Thank you very much. Okay. Division 1, Floor 6. And you are You, Mr.
Derek
Gordon?
Wolf.
Okay. All right. A little noisy over there.
Yes, it is.
Okay. All right. Today's,
Before you, Your Honor,
what's that?
was this before you?
This is Mr. Wolf, Derek Wolf.
Thank you.
You're welcome. Today is April 1, 2021. It's 3:14 p.m. This is a remote session of the Third Circuit Court for the County of Wayne Criminal Division. My name's Judge Lawrence Tallon. This is the case of the people of the state of Michigan versus Derek Matthew Wolf off the docket of Judge Gregory Bill. It's case number 17-000-589-01-FH. Here today to be arraigned on a violation of probation. Appearances, please.
Agent Graham appearing on behalf of the Michigan Department of Corrections.
Good afternoon, Judge. Neighborhood Defender Service by Glen O, P83424. Here on behalf of Mr. Derek Wolf, who's joining us from the Wayne County Jail on Zoom.
Okay, and good afternoon, Mr. Wolf.
Good afternoon, Your Honor.
Would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. You may put your hand down. Tell me your full name, please.
Derek Matthew Wolf.
And how old are you?
32.
And how far have you gone in school?
I completed a bunch of certifications in college.
Okay. All right. And you're on probation to Judge Bill. I believe it's for possession of less than 25 grams of a mixture containing the controlled substance cocaine, and that carries the maximum penalty of 4 years in prison. Do you understand that?
Yes, I understand.
And I guess I should have asked you, do you consent to appearing today remotely by way of Zoom?
I don't understand.
Is it okay that we do your hearing remotely on Zoom, on video, instead of in person in the courtroom?
If it works better for you, well then yes, that's fine.
Well, I want to know what's good for you.
No, I can do that too. So yes, that works good.
Okay, all right. And it's alleged you violated your probation because I have a report that says that on August 17, 2018, says you were arrested by the Plymouth Police on the charge of the possession of under 25 grams of cocaine and driving with a suspended license and operating while intoxicated, contrary to condition number 1. And at the time of the probation violation was signed, you were not in custody. And also that you hadn't made regular payments. Did I read the right one, Mr. O and Agent Graham?
Yes, Judge. And I have gone over the allegations with Mr. Wolf.
Okay, all right. You understand, Mr. Wolf, you have a right to a contested hearing on the charges?
Yes.
Good. You understand you have the right to the assistance of an attorney, and if you cannot afford an attorney and want one, the court would appoint one for you at court expense. And that if you're in custody, you have a right to have the hearing held within 14 days of being arraigned on the violation. Do you understand that?
Yes.
Would you like me to appoint Mr. O to represent you?
Yes.
Okay, I've done that. All right. And Mr. O, you had an opportunity to meet with Mr. Wolf?
Yes, Judge.
Okay. I noted on Odyssey that there were 2 CTN numbers. There was one out of the 35th District Court, 1872423, that corresponded, that looked like the prosecutor may have recommended a warrant for these felony charges, or at least the one felony out of on December 8th of 2018. And there was another one, 18719-176-01 for possession of less than 25 grams out of the 16th District Court, which is Livonia, that looks like may have been recommended on January 7 of 2019. Do either you or Agent Graham know anything about those cases?
Judge, as it relates to the 35th District Court matter, Mr. Wolf has been arraigned on March 29th. His future court date is for PCC in front of Judge Giroux on April 9th, 2021, scheduled for preliminary examination April 16th. His current bond on his Plymouth case is $50,000 cash surety 10% with the GPS tether. And attorney Sharon Clark Woodside has been appointed on his 35th District Court case.
Okay. Any information on the case out of 16th District Court?
Judge, I looked at the 16th District Court Register of Actions on the public website. I didn't see any 2018 cases. Maybe Agent Graham has more information on that matter.
Your Honor, from his lien, I only saw that he has a 3 warrants that are pending out of 16th District Court. And the warrants are dated from 2019.
Okay. All right. Okay. What is Mr. Wolf's pleasure on the probation violation at the present time?
Judge, because the allegation is new criminal activity arising out of 35th District Court, we're asking to track this case and we'd like to address bond at the appropriate time.
Okay, I'll enter a plea of not guilty on his behalf, as I assume that's your request, correct?
Yes, Judge.
Okay, the court has done that. Agent Graham, do you want to address bond first before I let Mr. O get the last word?
That's fine, Your Honor. This is the defendant's 3rd violation of probation since being sentenced. His previous violations were for failure to report. The defendant appears to be non-assaultive. However, it's concerning that he never avails himself to the court or reports as instructed. I would leave bond to the court's discretion.
Okay. Mr. O?
Yes, Judge. As it relates to Mr. Wolf, I think the most important point to start off at the beginning is that Mr. Wolf has not caught any new criminal activity since his 2018 cases.
Right.
It is a concern that Mr.
That's the other way to look at the failure to report.
Yeah, yes, Judge. The concerning bit is that Mr. Wolf is not availing himself to the court, but I think a GPS tether would sufficiently remedy that problem to keep track of where Mr. Wolf is. We'd be asking the court for either a personal bond or a low cash bond, given that he already has a $50,000 10% bond plus GPS tether on his Plymouth case.
I take it he hasn't posted that.
No, Judge. And Mr. Wolf does have a stable residence to return to if he were to be released.
I don't need to know the physical location, but what can you tell me about him? I am also concerned that he has a substance abuse problem. Even though he may not have caught a new case recently, it looks like he may have a substance abuse history.
Yes, Judge. Well, Mr. Wolf is employed. He cuts trees it's a seasonal job during the fall and summer. And when he's not employed at his Rely Tree Services job, he works as a farmhand for his father on his father's farm. His father pays his rent and food. So all income that he gets from his part-time job, plus working for his father, can be used to pay his court costs, which is the second allegation in the warrant.
Okay.
I'm sorry, Your Honor.
Go ahead.
I did also fail to note, the defendant does have a case from 2020, March of 2020, from 16th District Court, where he was arrested with possession of a syringe and possession of narcotics paraphernalia.
Okay. All right. I think I'm going to keep the bond at a remand for right now. And we'll send them, we can have them go to Judge Bill's docket either before or after the exam date. You said the PCC, the exam's April 16th.
Yes, Judge.
When do you want me to set a date in front of Judge Bill? I can wait till after the exam.
Judge, it seems to be taking 14 days after the bind over to get an AOY date. So maybe perhaps 2 weeks after the 16th.
Okay. Amber, do we have a date a couple weeks after the 16th in Judge Bill for in custody?
Yes, Judge, that date would be April 29th, docket A as in apple at 9 a.m.
How's that, Mr. O?
1 second, Judge. That works for defense.
Okay. All right, Mr. Wolf, you'll be seeing Judge Bill on April 29th at 9 a.m. Docket A, and in the meantime, I'm keeping your bond at a remand, okay?
What is a reback, sir?
A remand means that there's no bond. You're staying in jail until you see Judge Bill.
That long, okay.
Okay, all right. Thank you. All right, thank you, Mr. O. And thank you, Mr. Wolf. You can see, you can go with the deputies.
What was, don't I have a court appointment on the 9th of April?
Well, if you have, I assume that the Wayne County Jail, the sheriffs will be responsible of making sure that you either appear on the 9th, either in person or by Zoom, however that they handle that.
Okay. Well, why would this be so far away? I just don't understand.
Well, that because I want that case to resolve itself before your case goes to Judge Bill. If you're bound over on that case, you'll go in front of Judge Bill 2 weeks after that anyway. I suppose if it's dismissed, Miss Woodside could ask for an earlier date in front of Judge Bill.
Okay, cool. Thank you.
All right. Good
I
luck.
didn't know about that last part.
Okay. All right.
Thank you.
Bye. You can go with the deputies when they're ready.
Yeah. Oh, okay, right, there. This one? Yep. Your Honor?
Yes.
Are we, Mr. Gordon?
That'd be fine.
All righty. On the way, Your Honor, thank you.
Thank you very much.
Christ almighty.
How are you, Mr. O'Donnell?
Well, a little frustrated, Judge. I somehow got kicked off. But now I'm back. I have Mr. Hill and Mr. Drain.
Okay, all right. We've got Mr. Gordon, I think, first.
That's fine.
Today's April 1, 2021. It's 3:27 p.m. This is a remote session of the Third Circuit Court for the County of Wayne Criminal Division. My name's Judge Lawrence Tallon. This is the case of the people of the state of Michigan versus Albert Earl Gordon. Is that right? No, who do I have here? Did I say that right?
Albert Earl Gordon.
That's correct, Judge.
Okay, I wrote something. All right, very good. It's case number 19-007457-01-FH off the dock of Judge Deborah Thomas. Appearances, please.
Agent Graham appearing on behalf of the Michigan Department of Corrections.
Good afternoon again, Judge. Neighborhood Defender Service by Glen O, P83424. We have Mr. Albert Gordon, who's joining us via Zoom.
All right, good afternoon, Mr. Gordon.
Good afternoon.
Would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
You may put your hand down. Tell me your full name, please.
Albert Earl Gordon.
And Mr. O is your attorney?
Yes.
Do you consent to appearing today remotely by way of Zoom?
Yes.
Okay. Mr. Gordon's on probation for, it says receiving and concealing a stolen motor vehicle, second offense. What's the maximum penalty that he faces? And it's unclear to me because I looked on Odyssey and I couldn't tell, is that a habitual, penal code habitual, or is that a, in the stolen motor vehicle?
Your Honor, from our records, it has it as 10 years.
Okay, all right. So the maximum penalty you face apparently, Mr. Gordon, is 10 years in prison for violating your probation. You understand that?
Yes.
And it's alleged you violated your probation because you didn't go to the share house when Judge Thomas told you to. Says that one of the conditions that she just put you on was a GPS tether while at Mariner Inn. Said Probationer Gordon has failed to comply with his court order by refusing to be admitted to Mariners Inn on February 12, 2021. According to intake coordinator Portia Hardick Brown, on February 12, 2021, the defendant walked out of the facility within an hour of his arrival time from the Wayne County Jail. Probationer Gordon has made no attempt to contact this writer, the probation agent, and your whereabouts were unknown. You understand those are the allegations?
Yes.
You understand the maximum? Go ahead.
I don't mean to cut the court off,
That's
but
all right.
I have advised Mr. Gordon of his right to a contested hearing where the probation department must prove by a preponderance that what they're saying happened, the warrant did in fact happen. Mr. Gordon understands his rights and is choosing to plead guilty to the violation with an explanation.
Okay. All right. So, Mr. Gordon, you understand by pleading guilty, you face a maximum penalty of 10 years in prison.
Yes.
And you understand by pleading guilty, you're giving up your right to a contested hearing?
Yes.
Has anyone promised you anything if you plead guilty?
No.
Has anyone threatened you?
No.
Is it your own choice to plead guilty to violating your probation?
Yes.
Are you pleading guilty because you are in fact guilty?
I'm pleading guilty because they didn't, I couldn't go there because of my sexual orientation. They didn't want me there because of my sexual orientation. That's why I left.
Okay.
So it wasn't because I just left because I wanted to leave. They said I couldn't. It was a problem with me staying there.
All right. So let me ask you this. Do you plead guilty with an explanation to violating your probation?
Yes.
All right. And you went there and then you left, right?
Yeah.
And the reason you're telling me that you left is because you're saying they didn't want you there because of your sexual orientation?
Yes.
Okay. Were you on a GPS tether when you left?
No.
Oh, so you never got the tether put on?
No.
Okay. All right. And how did you end up getting back in jail here to see me here today?
The police, I ran into the police and they ID checked me and thought I had a warrant.
Okay. The police saw you someplace and they asked you for ID and saw you had a warrant?
Yeah.
Okay. You didn't call your probation agent after you left the Mariners Inn?
I don't know her name or her number, so it's kind of hard for me to call someone I don't know, and she don't make herself relevant. So it's just like, how am I supposed to call you? I've never met you before.
Okay.
She
All right.
never put an effort for me to meet her. I don't know, like it's just weird. And she
Okay.
want to say that I just refused. I didn't refuse anything. I don't know who you are.
All right. Okay. Thank you. Parties satisfied that Mr. Gordon's provide record factual support that he's guilty of violating his probation?
Satisfied, Your Honor.
Satisfied, Judge.
And that his pleas knowingly, intelligently, and voluntarily made?
Yes.
Yes, Judge.
And that the court's complied with the court rules?
Yes.
Yes, Judge.
All right. The court finds that Mr. Gordon has provided record factual support that he's guilty of violating his probation, that there have been no inducements other than those stated on the record. His pleas knowingly, intelligently, and voluntarily made. I'll accept his plea of guilty. Agent Graham, do you have a recommendation? Or should I be sending him back to Judge Thomas, who knows him much better than I do?
Yes, Your Honor.
Okay. Mr. O?
Yes, Judge. The matter should be in front of Judge Deborah Thomas. I think she knows the file better.
Okay, I agree. And I'm sure that that'll be good for Mr. Gordon too. Sound okay, Mr. Gordon?
Yeah.
Okay.
Judge, we would just ask for the next soonest available date.
Okay, I'm going to keep him at a remand because for obvious reasons. What's the next date for Judge Thomas?
Your Honor, if the court clerk does not know, I spoke with the capo for Judge Thomas, and she advised me that her next in custody date is April 9th.
Okay. And we don't know if that's morning or
And
afternoon. Go ahead.
It's docket B. B as in
Okay.
boy.
All right, that should be a 9 a.m. docket.
Your Honor, I got a job too since the last time I've been here. So I don't know what am I supposed to do? Call the job or I don't know.
Mr. Gordon, I can reach out to your employer by reaching out to your family and getting your supervisor's contact and letting them know the situation if you're comfortable with that.
Okay.
Okay.
Okay. And you'll see Judge Thomas on April 9, okay?
Okay.
All right, you take care.
You too.
Thank you. I don't mind you cutting me off, Mr. O. I know that you want to get to the point. That's fine.
I apologize, Judge.
No, you don't. There's no reason to apologize at all. I think it's part of a working relationship that happens in the courtroom with judges and litigators. So.
I think that's true.
Well, I'll be on standby if there are any additional duty attorney matters, but I think Jim has the rest covered.
Okay, thank you very much. Okay, and what is your name, sir? Okay, try again. In Division 3 with the white T-shirt. Your name, sir?
Anthony Drain.
Okay, thank you. All right, today is April 1 of 2021. It's 3:36 p.m. This is a remote session of the Third Circuit Court for the County of Wayne Criminal Division. My name's Judge Lawrence Talon. This is the case of the people of the state of Michigan versus Anthony James Drain, off the docket of Judge Noah Hood. It's case number 17-002446-01-FH. Appearances, please. Agent Graham.
Agent Graham appearing on behalf of the Michigan Department of Corrections.
Mr. O'Donnell.
Yes, Judge. Thank you. James O'Donnell, Neighborhood Defender Services, P42585, appearing on behalf of Mr. Anthony Drain. Mr. Drain, could you give the judge your name again?
Anthony James Drain.
Okay, Mr. Drain, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may put your hand down. Your name is Anthony Drain.
Yes, sir.
Mr. O'Donnell is your lawyer.
Yes, sir.
Do you consent to appearing today remotely by way of Zoom on video?
Yes, sir.
Okay.
Yes, sir.
You're on probation to Judge Hood for retail fraud, first degree, which carries a maximum penalty of 5 years in prison. And you were on probation for pleading eluding fourth degree, which carried a maximum penalty of 2 years in prison. Although that probationary period for that may have expired, I'm not positive. But in any event, it's alleged you violated your probation because it alleges you absconded from probation supervision, says you failed to report to probation since being released from the share house on October 30 of 2020, and that attempts to contact you at your house by phone and through your mother have been unsuccessful, and that your current whereabouts were unknown. Did I read the right warrant, Agent Graham and Mr. O'Donnell?
Yes,
Judge,
Your Honor.
That's the warrant that I have. I'm unaware of the fleeing and eluding warrant.
Oh, that wasn't a fleeing, I misspoke that. When he was convicted of these, on this 2017 case, he was convicted of both crimes, fleeing, eluding 4th degree and retail fraud 1st degree.
Okay.
And I know he was given 5 years probation, it says on the retail fraud. Is that right? 5 years? No.
All right, Judge.
So he may be on probation in both, faces a maximum penalty 2 years.
Now
on
that I
fleeing
look at the warrant, Judge, now that I look at the warrant, I can see both. Thank you.
Okay, all right.
Judge,
So
I've talked
go
to
ahead.
Mr. Drain, and he understands that he has a right to a contested hearing. He understands the maximums for the charges that he faces. He also knows that at a hearing, he could challenge the probation department's allegations. Judge, he wishes to admit the violations with an explanation. He would challenge one violation to the extent that it implies that he left share house. He says he did not. He says he completed it, but he will acknowledge that he failed to report for a period.
Okay. All right. Give me a second while I open this back up. So, Mr. Drain, you understand that by pleading guilty, you're giving up your right to a contested hearing.
Yes, sir.
And you understand you face a maximum penalty for violating your probation on count 1, retail fraud 1st degree, and 2 years in prison for fleeing and eluding 4th degree. Do you understand that?
Yes, sir.
Has anyone promised you anything if you plead guilty?
No, sir.
Anyone threatened you to get you to plead guilty?
No, sir.
Is your own choice to plead guilty to violating your probation?
Yes, sir.
Okay, all right. And how do you plead to not reporting to probation since being released from share house?
Plead guilty, sir.
Okay. And it's your position, though, that you successfully completed your program at share house?
Yes, sir. I completed that, sir.
Okay. You said you believe that?
No, I say I completed it.
Oh, completed it. Okay. All right. Thank
And
you.
Judge, Mr. Drain wanted the court to know that during the post-COVID period, he did see his probation officer. The probation officer came to see him. At some point, the probation officer gave him a phone number, told him to call in. Later, when he called in, the probation officer says, "You haven't reported enough, you're violated." And so he didn't make any further efforts to go see the probation officer or call him because the probation officer said you're violated. So he wanted the court to know he didn't completely ignore his responsibilities, but when he did attempt to fulfill them, he got discouraged.
Okay. What should I do, Agent Graham?
Your Honor, this matter does need to go back before Judge Hood. Also because the defendant's in custody currently because he has a new case. Geez, for the life of me, it just escaped me. It's in, I can't remember the number of the district court, but it's Browntown Township District Court. The date of the offense was March 30th, 2021. He was arrested for retail fraud or ticketed, I'm sorry, for retail fraud. And they have mailed a notice for him to appear on April 21st, 2021 for arraignment and pretrial at 10:45 a.m.
Okay, that's a separate criminal contact.
Do you have any information about whether he completed or didn't complete share house?
One second, Your Honor, I'm looking through the notes.
And whether or not he also claims that his agent told him he was visited or saw him since the warrant was issued or after share house since October of 2020, told him he was violated, and
he did complete the program. The defendant did leave a message for the agent to call him. Agent has not been notified. The agent attempted a home call, confirmed with family that he was out of treatment. Sent the defendant text messages. No contact is noted after the supervising agent went to the defendant's home and made contact with his family, other than the agent leaving messages and text messages for the defendant. It doesn't show that the agent made any contact, though. Just attempts were made. No note of the defendant contacting the agent.
you know, on September 30, Judge Heisey signed a order saying complete treatment at Share House, Detroit, inpatient. Share House will pick up Mr. Drain on Friday, October 2, 2020. And probation continued to June 10 of 2022.
That's correct. The defendant was noted that October 3rd, 2020, he had been admitted into the Share House program, and that he was likely to discharge. The note is dated October 27th of 2020, and the note says contact was established with his case manager and the defendant would likely be discharged on that Friday of that week. Instructions were given to the defendant to call the supervising agent.
So really, it looks like when I look at the warrant, it says he failed to report to probation since being released from Share House.
Correct. Not stating that he did not complete Share House, he just failed to report.
So what do you recommend I do?
As stated, Your Honor, I believe this matter needs to go back before Judge Hood, because the defendant now has new criminal activity, a new case for retail fraud, of which he is on probation for a retail fraud.
And what's your recommendation as to bond?
Due to the fact that he does not have a history of availing himself to the Department of Corrections, I would request remand.
Okay. And when is Judge Hood's next date, if that'll help me make a decision?
April 15th, docket B as in boy, 9 a.m.
Okay.
He does have a place to live, Your Honor. He lives with his mother at, apparently at the place where the agent visited at 4424 30th Street. He has a new phone number, which is different from the number on the warrant, and I'll give that to Agent Graham. His new phone number is 313-585-0118.
Okay. It appears to
And
me, go ahead.
Judge Hood actually has an earlier date, I apologize, of April 7 at 1 p.m. docket C.
Okay. What was that about when the agent had contact with him again? I'm always confused by why people stop reporting.
Are you asking me, Your Honor?
I think I'm asking Agent Graham.
Go ahead.
So let's see. Contact was established with his mother, asking that a message be given for him to immediately contact the supervising agent. A home call was done. Contact was established with his niece, and the niece told the supervising agent that they had just missed him and provided a phone number. The agent then called, left a message, and that phone number for the mother we have listed as 585-0118, the number that defense counsel just provided. But the phone number given by the niece was for the defendant. The supervising agent left a message for the defendant via voicemail and then followed in return with a text message.
Okay. All right. Anything you want to say, Mr. O'Donnell?
No, Your Honor.
I'm going to keep the bond at a remand for the following reasons. One, there's new criminal conduct alleged aside from the warrant. Two, there's the issues of his not reporting. Three, I see that there had been an earlier probation violation warrant that had been signed on February 10, 2020, alleging he absconded from probation supervision in that particular incident in that warrant as well. So next date will be April 7th, 1 p.m. before Judge Noah Hood. I can't remember if you said that was a docket C or a docket D.
She said docket C, Judge.
C like in Charlie. Okay. All right, Mr. Drain, you'll see Judge Hood then. Thank you very much. Okay, what is your name, sir?
Michael Terry.
Okay.
Judge, I don't know about Michael Terry. I know about.
Oh, that's a homicide case, and Mark Brown is the prosecutor, is the defense counsel on that. I don't know where he is right now, so let me take the other gentleman in Division 3.
That's
while
not mine either.
What is your name?
Oh, go ahead. Go ahead.
Willie Sims.
I didn't hear that, Judge.
One more, is it Maurice Tyson?
No, this is Mr. Sims. He was just seen like 2 days ago.
Really?
He said he has retained counsel, and who's your attorney?
Gary Jones.
Hey.
Gary Jones. Mr. Jones is present. Okay.
And Madam Clerk, I did just get into with APA Larry King, and he should be joining us shortly. He's the prosecutor that we dealt with this case 2 days ago. So I'm not sure why Willie's still in jail or why we're dealing with the tether violation, because Judge Bridget Hathaway, who his case is assigned to, has already handled this matter.
Judge, would you like to handle the Tyson matter while we wait for the prosecutor?
I'd be happy. Is that yours, Jim, Mr. O'Donnell?
No, I've got Kindall Hill. Kindall. Last name Hill.
Automatic voice message.
Yes, that looks like Mr. Hill.
Tyson is in VLP hearing also.
Okay. Today's April 1, 2021. It's 3:53 p.m. This is a remote session of the Third Circuit Court for the County of Wayne Criminal Division. My name is Judge Lawrence Tallon, and this is the case of the people of the state of Michigan versus Kindall Jaden Hill. Case number 19-006056-01-FH. Here to be arraigned on a violation of probation. Appearances, please.
Agent Graham appearing on behalf of the Michigan Department of Corrections.
And James O'Donnell of the Neighborhood Defender Services, P42585.
Okay.
On behalf of Mr. Kendall Hill.
And Mr.
Hill, could
Hill,
you give the judge your name?
I'm going to have him raise his right hand first. Raise your right hand, Mr. Hill. We lost you. All of a sudden, you're not in front of our screen for some other reason.
It looks like a different room.
Yeah, no, I think it's the same room. Can you hear me, Mr. Hill?
Hello?
Hi, we sort of lost Mr. Hill's.
Audio, video. One moment. It's getting turned back around now.
Okay.
Oh, yeah, there he is. Okay.
All right, Mr. Hill, raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
You may put your hand down. Tell me your full name, please.
Kendall Jaden Hill.
And Mr. O'Donnell is your attorney?
Yes.
You're on probation for 4 crimes, it looks like, under the Holmes Youthful Trainee Act. 1 for assault with intent to do great bodily harm less than murder, which carries a maximum penalty of 10 years in prison. Assault with a dangerous weapon, which carries a maximum penalty of 4 years in prison. Malicious destruction of personal property less than $200, which carries a maximum penalty, I believe, of 93 days in jail. And felony firearm, which carries a mandatory 2 years in prison, which would have to be served consecutively with and preceding any term of imprisonment imposed for assault, great bodily harm, and or felonious assault. Do you understand that?
Yes, sir.
All right. And give me another second here. And it's alleged you violated your probation. I have a warrant that was signed on September 29 of 2020 that alleges you failed to remain crime-free. It alleges that on September 17, 2020, you were mentioned in a Detroit crime alert for the offense involving CCW. On September 17, 2020, you were mentioned for the crime alert involving CCW. Detroit police effected a traffic stop on a vehicle traveling at a high rate of speed. As officers exited their vehicle, the driver was observed tossing a black object in the back seat with his right hand. The driver was identified as offender Kendall Hill. The offender was unable to produce a driver's license or paperwork for the vehicle. He was asked to step outside the vehicle and placed in custody for no driver's license. In a check of the vehicle, officers recovered a black semi-automatic from the back seat. He was arrested and conveyed to Detroit Detention Center for CCW, and the vehicle was towed. There was no court information. It also alleges you failed to perform 90 hours community service and failed to pay court costs and fees. You understand those are the allegations? You understand? All right. You understand you have a right to a consented hearing on the charges. Do you understand that?
Yes, Your Honor.
And that if you're in custody, you have a right to have the hearing within 14 days of being arraigned on the violation or to be released from custody pending the hearing. Do you understand that?
Yes, Your Honor.
Okay. All right. Okay. It looks like Mr. Hill has a new case of 21-000797-01-FH. Is that based on this new criminal conduct?
Yes,
Yes,
Judge.
Your Honor.
Okay. How does Mr. Kendall wish to plead to the violation?
Judge, he's aware of his right to have a hearing on this. He's aware of the allegations. He's aware of the maximums. Judge, what he'd like to do is to tell you that he will acknowledge that he failed to perform 90 hours of community service and to pay costs and fees. He will tell you that he's been employed as a landscaper and he has money and he was prepared to pay $500 toward their costs and fees. He wants the court to know that he has made all court appearances regarding this new case, that there's been no problems in his life other than this new case. I've talked to his attorney on his new case who says that they were both prepared to appear in court on March 3rd, 2021, but the judge was not present. He is prepared to challenge some of the aspects of that case. I'm not prepared to talk about that case now, but I would ask the court to place him back on probation, or at least have this case trail while this new case is pending. He will pay costs. He says he's told his probation officer that he does not want to do community service. He wants to pay full costs, full court costs, and other fees.
All right. So on the new case, he was bound over on CCW. He was given a $1,000 personal bond by the district court judge. He was scheduled for arraignment on the information on March 3 of 2021, and it was adjourned to May 13 of 2021. That's Brandy Robinson's case, is that right?
That's right, Judge. I've spoken to Ms. Robinson. She said
let me think out loud.
Okay.
Should I arraign him on that information? Can I do that?
You certainly can, Judge. If that's the case, I'd waive the formal reading and stand mute.
Okay. All right. So I will call case number 21-000-797-01-FH. And I can't remember if I asked you, Mr. Hill, do you consent to appearing today remotely by way of Zoom?
I don't know what that means.
Is it okay we do this on video?
Yes.
Okay, all right. And is it okay that Mr. O'Donnell stands in for Ms. Robinson on your concealed weapon case as well?
Let me quickly intercede here. Mr. Hill, all I'm doing is entering a plea of not guilty for you in this case. Your attorney is still Ms. Robinson.
Okay. All right. Yes, that will be fine.
Okay, so the formal reading's been waived. I'll enter a plea of not guilty on his behalf. I'll make the next date the same date before Judge Thomas, May 13 of 2021. We'll call that a docket conference before Judge Thomas. How about if, with regard to the, I was thinking that on the violation,
Yes,
that I should just enter a plea of not guilty on his behalf and let it tag along.
Yes,
Let Judge Thomas decide this. Any objection to that?
No objection from NDLC, Your Honor.
All right. So I'll enter a plea of not guilty on the probation violation. And I'll give him I was going to give him a personal bond on that one as well, since I'll give him a $1,000 personal bond on that as well.
Very well. Thank you, Your Honor.
Your Honor, if I could just get Mr. O'Donnell to provide contact information or confirm if the address on the warrant is still valid.
I'll give you the address he gave me.
She doesn't want it on the, she doesn't really, I don't think want to put it on the record.
All right, Judge, I'll put it in the chat.
Thank you.
All right. And do you want Mr. Hill to start reporting to probation again or continue?
Yes, Your Honor. He does have to contact the probation department once he's released from the Wayne County Jail.
You know how to do that, Mr. Hill?
I do know how to call, but just for the worst kind of words, what office are you out of?
Can we give them the number? Maybe the deputy can.
I wrote it down for him, Judge.
Okay.
Thank you.
May I have the next court date, and was it for both cases?
May 13, 2021, Judge Deborah Thomas.
Thank you.
Okay.
And
All
that's her number or the case number or
The one I'm giving you,
Yeah.
it's for probation, it's the.
that's right, it's the probation officer.
And you've got Mr. Hill's contact information, Mr. O'Donnell, so you and Ms. Robinson can be in touch with him to make sure he shows up on May 13th?
Judge, I have that and I'm putting it into the chat box right now.
Okay. All right. Any questions, Mr. Hill?
No. Thank you. Appreciate it.
Well, all right. Do the right thing, okay?
Yes, sir.
Show up for court, report to probation. Okay, very good.
Your Honor, I'm sorry, what was the amount of that personal bond?
I did $1,000 personal bond, which is what he was on the new case. And the reason I did that is my recollection is that the allegations in the new case were not new, and he's been reported to court on the when he's supposed to.
Okay, thank you, Your Honor.
Okay, all right.
And Ms. Graham, do you see the information in the chat box?
Yes, thank you.
All right, you're welcome. Thank you, Judge.
You're welcome.
Thank you.
Okay, would you like Mr. Sims or Mr. Tyson?
Which one do you want, Mr. O'Donnell?
Judge, those are not my cases. If you need someone to stand in, I will, but.
Okay. What about
I've got Mr. Sims, Your Honor, and we're ready. And I have the APA, Mr. Larry King, who's on the Zoom as well.
And Judge, if you need me back again, Amber Taylor knows my phone number.
Okay.
Your Honor,
All right.
Mr. Tyson is a violator.
I'll put it in the
He
box.
spoke with Ms. Morgan earlier. I think that you said that was your part or coworker or something, Mr.
Maurice Tyson?
Is that Joan Morgan?
Yes.
Yes, he said he spoke with Ms. Morgan earlier when she called the other violators.
And his last name is Tyson?
Yes.
All right, I'm gonna go out and come back in. I'll see if, I may have gotten some notes about Mr. Tyson. I'll be back in a minute.
Yeah. What happened to Mr. Halliburton?
Your Honor, he was already arraigned previously by Judge Thomas.
Oh, good. All right, so I don't have to worry about him.
No.
Okay, so we're doing Willie Sims, is that right?
Yes, Your Honor.
Okay, let me get his info up here. All right, today is April 1, 2021. It's 4:06 p.m. This is a remote session of the Third Circuit Court for the County of Wayne Criminal Division. My name is Judge Lawrence Talon. And these are the cases of the people of the state of Michigan versus Willie Earl Sims. Is that right?
That is correct, Your Honor.
Okay, and their case number is 18-003467-01-H and 18-008639-01-FH. Appearances, please.
Mr. King? Judge, do you see Larry King? Has he been let into the?
I don't see Mr. King.
Mr.
He
APA
was there,
Larry
Judge.
King?
I just now admitted him again.
Are you on there, Larry? They're calling. You're in the waiting room? All right. Judge, for the purposes of today's hearing, we would consent to using Zoom as the median. And while we're waiting on Mr. King to get in, Gary Jones, P number 56072, appearing on behalf of Willie Sims as to both matters.
Okay.
And Judge.
So let me quick on the 3467. I see an order dated March 30th, 2021 by Judge Gregory Bill says a motion to reinstate $5,000 personal bond with GPS tether is granted.
That shouldn't be by Judge Gregory Bill. That should be by Judge Bridget Hathaway. And so she would be the one who handled that matter, Your Honor.
Your Honor, Mr. Jones, I seem to have audio again, and I apologize for that. This is APA Larry King.
Okay, well, my guess is that looks like Judge Hathaway's signature, even though it's got Judge Bill's
stamp
printed.
I do want to put on the record that Judge Bridget Hathaway's staff, as well as Courtroom, went out of their way to help us on this case, and we're thankful to Judge Bridget Hathaway.
So what's the problem?
I don't know. Somehow he should have been released 2 days ago, and poor Willie has been sitting in lockup. I don't know if it's because he's waiting on a tether or if there is a tether, but I thought they had removed the tether quite a while ago, and here he is. You know, and I don't know what's going on, but he should. My understanding is he should be out. He shouldn't be on a tether. We should be.
The order says with GPS tether.
Well, maybe that's why we're here, so that I can argue for it not to be on, because I don't think he had one. He was out. I know he was out, and when he would come to my house, Judge, and I'd sit with him. I didn't ever see a tether.
Your Honor, I am on a different file, not even the files that are before the court today on the docket, but a 2020 domestic violence case. And the bond conditions in that case have always included a GPS tether. So I don't know.
Well, then maybe that's what the situation is, Judge. How many cases does he have open? Because I was on 2 2020 cases, and you mentioned an 18 case. Am I listed as the attorney of record on that, or what are they involving?
Hold on.
Maybe we might need a formal reading or something.
What's his date of birth?
Willie. Mr. Sims, can you hear us?
Yes, I can.
What's your date of birth?
12/17/71.
Okay, so there's case number 20-001115-01-FH, which was scheduled for March 29 of 2021 before Judge Bridget Hathaway. And
he wasn't there because he was locked up. And I appeared for that date on the 29th. And then they brought him over the next day, Judge.
And
the 30th.
It was adjourned. Well, for whatever reason, that case was not called before Judge Hathaway, because on March 29th of 2021, Odyssey says she adjourned it to April 21 of 2021. And that the bond in that case is $5,000, 10%.
Is that the license plate forgery case that APA Blackburn is currently assigned?
No, the one I just read is charged with felon in possession, FA, 2 counts of felony firearm, and domestic violence.
That would be my file.
And it says the bond is it says it's been posted. It says it was posted March 23 on that case. His middle name's not on Odyssey on that case.
I don't know. Judge, all I know is that he was brought before the judge. This is weird. Well,
It's my understanding
So
he was arrested on probation or probation violations related to the 2018 cases. And that's what he was before the court on when we were with Judge Hathaway previously. He also has a case pending with APA Blackbird, who's the APA of record. And I do believe he should be joining this Zoom call as well.
How many cases do we got, Judge?
What's that? I have a simple answer. Let's set it up for the next date before Judge Hathaway.
Well, wait, no, Judge, because I don't want to listen. I don't want him sitting any longer than he has. He's about to lose his job.
Wow.
And this young man, these 18 cases, we dealt with the 2020 cases.
I can tell you, Odyssey says he's posted the bond on the new case, and on the other cases he's got personal bonds with GPS tethers. So
okay, so then he should be out.
Well, maybe they're going to give him a GPS tether. I don't know.
Judge,
Yep.
I don't want to interrupt the record. This is Officer Cotton. I think what happened was he came in on a tether violation for that 20 case. And I don't think that was addressed. Maybe that's why he's on the docket. But the other day when Judge Hathaway seen him, we only have paperwork for the 18 cases. So maybe the jail just needs paperwork on that 20 case to maybe reinstate that bond, or I don't know, whatever the judge decides to do, but we need some paperwork for the 20 case.
Okay.
And Judge, I do appreciate you taking the time to handle this on the emergency docket. I do recognize that our court is limited with the number of court clerks we have.
Okay, let me get to the point. All right. So I can enter an order on the 2020 case. Reinstating the bond that's already been posted. I've got a bond number and everything.
Whatever we got to do to free will it.
He still has the GPS tethers and personal bonds on the two other cases that Judge Hathaway said.
No objection to reinstating the bond, Your Honor.
Judge, just so that I'm clear, how many cases does Willie have, though? 4? Is that what the court's telling me?
What?
Because I thought some of them should be closed. The 18s, aren't there? Let me see this thing.
Okay. All right. Okay. I'm on to the next case because I've got more cases, more ground to cover.
So what are you saying?
Judge Bridget Hathaway entered personal bonds with GPS tethers yesterday on those 18 cases. On the 2020 case, I'm reinstating the bond that was posted.
There was another two in 2020. And I know you got a lot of docket, Judge. There's another 2020 case. There's 2 of them. We need that one reinstated as well. That's on a driving case, right, Mr. King? Mr. King?
Excuse me, this is your court reporter. Are you still on the record?
Yes.
With this
Yes.
case?
Mr. King?
He's gone.
APA Gregory Blackburn on behalf of the people. I have one of the 18 cases. It's a license plate case. It looks like there's a 2018 case that he's on probation for, some kind of drug case. And then there's a 2020 case, which Mr. King is the APA on, which is the domestic violence case. So there's 2 open cases, 1 probation case. So there should be, I suppose, 3 bonds total. And it sounds like the 2020 case is the one that needs an order entered so the jail can release Mr. Sims.
Yep. That's what I'm going to do. And the next date on that 2020 case is
April 21st, you said?
Yep. Yep. Whatever date was in the in Odyssey. Okay. All right. Thank you.
Nice seeing you again. And if Amber needs to contact me, I can leave Amber my number too, Judge.
All right.
It's 313
Thank you, Judge.
850-7906 if Amber needs to reach me.
Okay. Let's take care of Mr. Terry, if we can.
Thank you.
All right. This is April 1, 2021. It is 4:19 p.m. This is a remote session of the Third Circuit Court for the County of Wayne Criminal Division. My name's Judge Lawrence Tallum. This is the case of the people of the state of Michigan versus Michael Terry. It's case number 21-000330-01-FC. Appearances, please.
Dominic DeGrazia on behalf of the people.
Good afternoon, Your Honor. May it please the court, Mark Brown up here on behalf of Mr. Terry.
Okay, good afternoon, Mr. Terry.
Good afternoon, sir.
Would you raise your right hand, please? Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down. Tell me your full name, please.
Michael Terry.
And Mr. Brown's your lawyer?
Yes, sir.
And do you consent to appearing today remotely by way of Zoom?
Yes, sir.
Okay, all right. You taking care of yourself after our last talk? Okay, good.
Yes, sir.
All right, good. I know that I got an email today from my clerk saying that Mr. Brown had contacted our office to see if the exam transcript had been in yet, and it has been filed now and uploaded. So I wanted to put that on the record. What else can I do for you today, or do I need to set another date?
What exam?
Mr. Brown or Mr. DeGrazia?
Judge, I think we just need another date because I think Mr. Brown was planning on filing some motions.
Yes, I think the preliminary examination transcript was uploaded today. I got an email with the transcript today, Judge. So,
and I forget. Is your motion going to be based on the transcript?
No. Well, it possibly can. I want to talk to Mr. Terry about that.
Okay.
Yeah.
When do you think we should come back?
Maybe 3 weeks, Judge.
And that, so if we come back in 3 weeks, that'll have given you time to file your motion. Mr. DeGrazia will need to respond. I mean, do you anticipate we'll be setting an evidentiary hearing or be asking for one?
Yeah, I think what we were talking about before is evidentiary hearing for the suppression of the statement, possibly.
Okay,
so that's,
I've forgotten. Okay.
Yeah.
So if you want to, okay. So if we set one in 3 or 4 weeks, what we'll probably be doing is then talking about what we need to do to set a hearing date.
Yes, sir.
Maybe we talked about it before that I need a witness list for the evidentiary hearing.
Okay.
Okay, let's look at the calendar. I've got a April 27th, a Tuesday in the afternoon at 1 o'clock. Or the 20th at 9 a.m.
Judge, the 27th, I've got an in-person hearing set for 10 a.m. or 11 a.m., so that might be bad.
So should we try April 20 at 9 a.m.?
That's fine with me.
Actually, the 20th would probably be better for me also, Judge.
Okay, April 20, that'll be docket B, like in boy, or baby, or Brown, come to think of it, and 9 a.m.
Thank you very much, Judge.
Okay. All right.
All
You're
right.
welcome. Thank you,
Thank
Mr. Brown. Thank you, Mr. DeGrazia. Take care, Mr. Terry. I'll see you then.
Thank you.
All right, thank you.
Okay.
Thank you.
Okay. Bye-bye.
Judge, this is Jim O'Donnell on the Tyson matter. I do have the warrant. I do have notes from an attorney who interviewed him this morning, but I probably need a moment with him to find out what he's going to say about the allegations.
Okay. So, Amber, can we put him in a breakout room, or? And who's the gentleman we have right there in the lower left there, Division 3?
This is Mr. Tyson.
Okay, that's Mr. Tyson. All right, that's who you need to meet with.
Yes, sir.
All right. Okay.
Thank you.
Do I remember correctly? That's Mr. Tyson that he's meeting with?
Yes, Judge, that's correct.
Okay. I see Judge Hathaway gave him a remand.
Your Honor, there was a mix-up. The defendant has two cases, and there was a mix-up when he was arraigned on his other case, which belongs to Judge Deborah Thomas. He was originally arraigned by Judge Knapp. And they were under the assumption that our warrant was not signed. And Judge Knapp didn't want to deal with our case. So it was just a confusion. So he wasn't arraigned on ours at the same time he was arraigned on Judge Thomas's. So the Judge Thomas matter has already been addressed and he's been continued on it. And he just had to be brought here for ours.
What date was he in front of Judge Knapp?
1 second, Your Honor, I'll look it up. On March 22nd, Your Honor.
Oh, that was before our warrant was actually in Odyssey, I think.
Yeah, it was a mix-up because it was actually signed in January.
It looks like he's got a case out of 32A though.
Yes, and that was something that you were previously made aware of that in a previous warrant where he was continued on probation. Should I say you were made aware of the case when it was pending?
So the other case he's on probation to, that's to Judge Thomas? Is that the 7325 case?
Yes.
Okay. And she signed a continuation.
Yes, with
6 months MDOC tether, complete domestic violence training.
Yes.
All right. Okay. All right. Today's April 1, 2021. It's 4:33 p.m. This is a remote session of the Third Circuit Court for the County of Wayne Criminal Division. My name's Judge Lawrence Tallon, and this is the case of the people of the state of Michigan versus Jeffrey Maurice Tyson, 18-00877-9-01-FH. Appearances, please.
Agent Graham appearing on behalf of the Michigan Department of Corrections.
And good afternoon, Your Honor. James O'Donnell of the Neighborhood Defender Services, P42585, here on behalf of Jeffrey Tyson.
Okay. All right. Good afternoon, Mr. Tyson.
Good afternoon, Your Honor.
Would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
You may put your hand down. Tell me your full name, please.
Jeffrey Maurice Tyson.
And Mr. O'Donnell is your attorney here?
Yes.
And do you consent to appearing today remotely by way of Zoom?
Yes, I do.
Okay. So, Mr. O'Donnell, while you were talking to Mr. Tyson, I was talking to Agent Graham trying to get up to speed. And I see that in this other case that he had before Judge Thomas, which was 18-007325-01-FH. You want to write all that down?
No, Judge, I just got a phone call and I just switched it off. Go ahead, Judge.
Okay. On 18-7325, that on March 18th of 2021, Judge Knapp, on behalf of Judge Thomas, I believe, continued his probation on that particular case where he's on probation for domestic violence third to February 19th, 2022, and put him on 6 months MDOC tether, order that he complete domestic violence training, make monthly payments toward costs and fees. Apparently, Judge Knapp didn't address this court because for the warrant that I signed back in January didn't get entered into Odyssey, apparently. And so that's why he's here today, unfortunately. And when he was in front of Judge Michael Hathaway, Judge Hathaway on this case just remanded him. So are the warrants based on the same conduct in the two cases, Agent Graham?
Yes, Your Honor.
Okay. So let me ask you what I should do.
Your Honor, I have no objection to you continuing the defendant on probation to his term of March 15th, 2022, and making the conditions the same with 6 months MDOC tether, complete domestic violence training as ordered. And I believe that was the only other condition, and all original conditions to remain in effect.
Well, I'd have no objection to that.
Okay. Sound reasonable, Mr. Tyson?
Yes, Your Honor.
Okay. All right. I'll do that. Go ahead.
Excuse me, Your Honor. We do need a valid address and phone number for the defendant. The telephone number he provided previously is not valid.
Okay.
I can put a valid phone number. It's for his brother because he doesn't have a phone, which is one of the reasons he was having difficulty zooming into his DV classes. But I will put that in chat.
Okay. I just need to make sure we're in communication, Mr. O'Donnell, if the number is the same as what I have. So
I think this is a different number.
Okay. You want me to put all three of you in a breakout room?
No. Let me just give her a phone number.
All right.
It's so good of you to facilitate.
I've got a 6260 number here. Is it the same number or is it a different one? The last four digits.
No, it's a different one.
Okay. All right. So I'll continue him on probation to March 15, 2022. All the original conditions will remain in effect. In addition, it'll be 6 months on an MDOC tether, complete domestic violence training, make monthly payments toward costs and fees.
And still no contact with Cheryl Tyson.
No contact with Cheryl Tyson.
That was noted previously.
Okay. All right. Okay, Mr.
Okay.
Tyson? Okay.
Yes, thank you, Your Honor.
All right.
Appreciate that.
You're welcome. Take care. All right. Thank you, Mr.
Okay.
O'Donnell. Okay.
Thank you, Judge. That's all we have at Division 3.
Okay. Thank you.
Are there any clients I need to stand around and help? I'd be glad to help the court if it needs any help.
The court definitely needs help, but I think
But you
we
might be
finished-
done for the day.
I think, well, with the docket anyway.
Yes.
With the defendants to see. Now we have to do get the paperwork done, things like
Well,
that.
as before, I'll tell you that Amber knows my phone number. So if you're needed on some case, call me.
All right. Thank you.
Thank you,
We all
Judge.
set, Amber? Oh, he's gone. All right. All right.
Have a good day, everyone.
You too, Agent Graham. And thank you, Miss Rhodes.
Oh, you're very welcome. Have a wonderful evening.
You too.
Thank you. Bye.
Okay. All right. I'll stop I guess, Amber, you've got to stop the YouTube and stop the recording now.